Hello and welcome everyone. So thank you very much for joining our very first event as part of our Deep Tech Innovation Centre series of Twilight events. So the agenda for today, the actual title of the event is Inspiring the Next Generation of Deep Tech Innovators, Key Lessons for Startup Success. So just before we start, just a little bit of housekeeping. So if you can all keep yourself on mute and off the video, that would be great. But I really want to make this a very interactive session. So if you can post any questions you have during any of the speakers' sessions or as part of our panel Q&A, please post them in the chat. I will pick those up and share those with the speakers as we go through. So really keen to make this as interactive as possible. So thank you very much for that. The other bit of housekeeping, so we are recording this and we'll be sharing this online after the event as well. So just for your information. So thank you all for joining. We've got a great agenda today, so I'm going to sort of start by giving a little bit of an introduction into the Deep Tech Innovation Centre and just give a little bit of background on that and touch on the Warwick Innovation District as well. I'll then hand over to our speakers to sort of cover different aspects of startup success. And then after the three talks, we'll then have a short panel session for any further Q&A as well. So we're very honoured to have three amazing speakers, and I'm very proud to say they're all Warwick alumni as well. So we've got some great experience sort of joining us this evening to sort of talk about different aspects. So we've got John starting us off talking about intellectual property and some of the blunders and success stories. So that's going to be quite interesting to sort of see how that relates to startups and what the right approach is to do there. So really interested to hear from John. We've then got Tom, who will be giving us some insight in the kind of the collaboration between startups and enterprises, and this is particularly interesting and relevant for people or companies that are trying to get their first few customers, and especially for startups where their customer or target customers are going to be the large sort of corporates and enterprises. So it'd be interesting to sort of get an insight from Tom on that. And then last but not least, we'll have Ben, who will be talking us through how networks can really supercharge the growth. And Ben comes with a whole heap of experience and was the former head of Level 39. So we'll have seen a lot of startups going through Level 39, and I'm sure he's got some great insights and experience to share with us. So that's the format for the event and for the talks. But what I wanted to do is just spend a few minutes talking about the Deep Tech Innovation Centre, and this is a new initiative for Warwick, and this series of events is really twofold to help to promote the Deep Tech Innovation Centre and what its ambitions and mission is, but also to inspire future deep tech founders, and that's really what this series of events is all about. So the vision of the Deep Tech Centre is to inspire every innovator, and our mission is really to cover that sort of inspire, educate and incubate, and I'll talk a little bit more about that on the next slide. So the Innovation Centre is fairly new, as I mentioned. So we're just sort of starting this, launching this this year, and we've got a innovation framework that has been developed as part of the Warwick Innovation District and is used by a number of the different incubators that we have at Warwick, and I'll sort of highlight that a little bit later on. But we have three core pillars of the framework. So the first is around inspiration, and this is where we run different events to inspire potential innovators. We're going to be running challenges and working with corporate partners and running hackathons and all of those wonderful things that really start to get the sort of innovation and ideation for people to sort of think about how they might leverage their ideas and their research and turn that into a sort of corporate or commercial endeavor, essentially. We'll then have a separate pillar all around education, and we have a number of different programs that we'll be running throughout the year around that. And then, of course, that leads into the more traditional sort of incubation, where we help founders to sort of take their ideas, develop it, incubate it, create an MVP, and then look to create a startup off the back of that. And we have a whole range of different support programs that will be running to sort of get that off the ground. And I'll share a timetable with you a little bit later to highlight what we're doing there. So the outcomes of the Deep Tech Innovation Centre is not just going to be about the business growth or the incubation of startups, although that's obviously a core part of what we're doing. But we're also, as almost a byproduct, if you like, going to be helping around the education and really ensuring that the curriculum is relevant for the Warwick courses and helping to develop those, helping to create opportunities, particularly in partnership with corporates for internships and placements, and essentially, running programs that essentially try and bridge between the university and external partners. The partners are particularly important for us at the Deep Tech Innovation Centre. We really need them to help us understand some of the challenges that organisations have and to actually help understand the commercial aspects of that for the startups that we have. So we're very keen on fostering partnerships with corporates and helping to solve some of their real life problems, but as part of that, incubating our startups as well. So that's super important for us. And this, of course, drives the research as well. So we see these sort of stimulating these new ideas and projects will bring together academics, students and businesses and really be that sort of test bed for new ideas and approaches and to create those new products and startups off the back of that. So it's a real sort of ecosystem that's bringing all of these different key stakeholders together and to sort of move us all forward in the development of these deep tech startups. So that's a wide range of outcomes that are coming from the Deep Tech Innovation Centre. As part of this, we'll also be running challenges and competitions, and again, this is really to collaborate with partners who will have a lot of the real life challenges and the data that we can use with our startups and founders to really sort of move their thinking forward on their ideas, but sort of matching that with corporate challenges. So we see this as very, very important as part of the wider set of programs and activities that we're running as part of the Deep Tech Innovation Centre. And of course, we need your help. So, the whole point of these events is to sort of promote what we're doing and to reach out to potential partners and mentors that we can sort of bring into to support these activities. And so, if you are interested to learn more about this, please get in touch with me, and I'll be sharing my email address a little bit later. And now to the timeline, so as I mentioned, we're really just starting with the Deep Tech Innovation Centre, and this is the first of a number of what we're calling twilight events for obvious reasons, that is really around the sort of inspirational part of our sort of three pillars for the centre. So we also run Innovate to Impact programmes as part of that inspiration as well, so we're trying to run one every term. On the education side of things, we have the iCure program, which is an established program that we run frequently at the university. So again, this is to help potential founders and innovators understand the commercial viability of their research, and this program is essentially a feeder into our incubator essentially. So that's a really important program that's well established, and we continue to run that, and that's really a sort of core keystone of our sort of education pillar. And then the incubation itself, so we are looking to start our first cohort March next year, and already starting the sort of recruitment of the cohort. One thing to say about the incubator, so obviously this is very much Warwick focused, but the incubator is open to everyone, so you don't have to be a current student or alumni of Warwick. We're open to anyone to be part of the incubator. So while there is obvious focus on our sort of student pipeline, we're very much open to anyone that's interested in being part of our incubator. And again, as part of that, we'll have an undergrad boot camp and graduate accelerator as well. So that's the sort of timetable that we've got for all of our activities, programs and incubation. And just to say that our next event is actually going to be in collaboration with the Warwick Technology Professional Network on Wednesday, the 2nd of December. So we'll be sending out details of that later on, but please pencil that in. It'd be great if you could all join us for that as well. And we have a website, so if you're interested to learn a bit more, please visit deeptechinnovation.org.uk. And if you would like to learn more or to follow up on being a partner or a mentor, then please drop me an email at andrewpardoe@wbs.ac.uk. So just a quick word on the Warwick Innovation District. So we've got a strong history of innovation centres at Warwick, and this just sort of gives you a bit of an insight into all the different centres that we have as part of the district, and we're very pleased to be part of that ecosystem, and the Deep Tech Innovation Centre to join all of these other centres, and looking forward to collaborate across these centres as well as across all the different departments within the university. And so we've got to the point now where we're going to hand over to our speakers. So I hope you've got yourself a favourite tipple. Normally when we run these kind of events pre-COVID, we would have had some networking and some drinks ahead of the talk. So hopefully you've taken my advice and got yourself a drink of your preference to sit back and enjoy our speakers. So with that, I'm now going to stop sharing and hand over to John, who will be our first speaker. So let me just stop sharing.
Okay, thanks very much, Andy. It's certainly a pleasure to be here on this for this inaugural event. So yes, I'm a patent attorney and I work for a company called HGF. So as a patent attorney, my primary responsibility is basically helping new companies and companies, startups, to protect their innovations and basically stop their competitors stealing those ideas. That's basically it in a nutshell. The clients that we have, they range from startups, private individuals, through SMEs and universities, and all the way up to big multinationals like Samsung and Intel. So when Andy and I spoke about doing a presentation this evening, he suggested that I might do some IP blunders and success stories as to provide some sort of salutary lessons and some inspiration too. I have to say that it was easier to find the blunders than the success stories. I suspect though that's just because they tend to make the headlines a bit more and perhaps a bit more memorable. But there are plenty of both, so that's going to be the focus of my 20 minutes. So fairly short agenda. We'll look at the pitfalls and success stories, but just before that, I'll just do a very, very brief introduction to intellectual property for those of you who perhaps aren't too familiar with it. Okay, so what is intellectual property? Well, it's basically in the name. So it's intellectual in the sense that it's things that arise from the creativity of the human mind. So not necessarily tangible things, they can become tangible, but in terms of their origin, they come from the creativity of the human mind. So we've got a few examples here. I don't know if you can see my cursor, but I'm basically going to work my way around anti-clockwise from the top left. So we start here with an example of a manufacturing process, for instance. It might be a product like a transistor. It could be a company name or logo. It might be a musical work or a literary work. It could be some packaging for design for packaging, or the design for the externals of a car, for instance, or it could be a piece of software. All just examples. There's many more that are possible, but fundamentally all intellectual in terms of their source of creation. And it's property in the sense that just like a tangible asset, it can be owned, it can be property, especially if you protect it with an intellectual property right. And that's the next slide. So the law has defined various different types of intellectual property right to protect different types of intellectual property. So they're basically 5 types. The first one is patents. So that's for protecting the way that something works. So that could be an invention, for instance, or an idea. Trademarks, that's for protecting something which is capable of distinguishing origin. So it could be something like a company name, a company logo, could be a colour, so Sainsbury's orange, for instance, or it could be a sound like the jingle that you hear on an Intel advert. Designs, registered designs and unregistered designs, that's for protecting the aesthetics of something, the way something looks. So it could be, for instance, the iconic shape of the glass Coke bottle, or the way that a Dyson vacuum cleaner is very distinctive, the way that it looks. Copyright, that's for protecting the way that something's expressed. So that could be a literary work, a work of drama, a music or artistic work, that kind of thing. And then confidential information, that's really about protecting intellectual property by means of contracts, so agreeing to or not to do something with regard to a particular piece of intellectual property. So that's my whole introduction to intellectual property, very, very brief, and there's lots more to it, but if you've got questions on that, perhaps we can do that at the end. So straight on to some pitfalls first, and then we'll save the success stories for the end to be a bit more inspiring. So the first pitfall I've identified is overlooking IP, be that your own or that of others. So this is an example that involves Rolls-Royce Motor Company. So in 1998, BMW and Volkswagen entered a bidding war to buy the Rolls-Royce Motor Company, which was being sold at the time by Vickers. And BMW were heading the way. They had the top bid, and Volkswagen came in at the end and outbid them. And for their purchase, Volkswagen got the Rolls-Royce administrative headquarters, the production facilities, and even some of their IP. So the Spirit of Ecstasy, the famous hood ornament on the bonnet, the car designs themselves, and the iconic big rectangular grille shape. But they'd overlooked a big IP detail with massive consequences, and this wasn't overlooked by BMW. And that was the fact that Vickers didn't actually have the right to sell the Rolls-Royce name or the Rolls-Royce logo, which you can see on the back of the overalls at the top there. Those were actually owned by Rolls-Royce PLC, the jet engine maker. And so basically Volkswagen found itself in a very difficult position because it had a load of assets that really were valueless, because without that key piece of IP, the ability to put the name on the car and the logo on the car, nobody would want to buy those cars. And obviously there was some wrangling between BMW and Volkswagen, but basically today this is why Volkswagen has concentrated its efforts on making Bentleys, and BMWs are made by Rolls-Royce. Bentley, at the time of the sale, it was included in the sale as a make-weight really by Vickers, but VW were basically forced to focus on this because they'd missed this really important piece of IP. So just shows you, look out for where the true value of your business is, and it could be in a piece of IP which might be easy to miss. So the second pitfall is that for an idea to be patentable, an invention must be new. And that means that you really need to keep your inventions secret if you want to patent them and have them protected. That is, before you've applied for a patent application. So just to unpack that slightly, so to be patentable, an invention must be new. So that means it must not have been made available to the public before you apply for your patent application. And in even more detail, it's very wide-reaching. So that means that you must not have disclosed your idea to anyone, anywhere in the world, in any language, except under an obligation of confidentiality, be that express or implied. So that means even as the inventor, you can prevent yourself from obtaining valid IP protection or a valid patent by disclosing your idea before you file for your patent application. So do keep your inventions confidential. Another story of this going wrong, or very nearly going wrong, I don't know if you've seen the hoses, the new design of hoses. So obviously you'll be familiar with like a hose reel, but now you can buy these hoses that effectively stretch out, so it does away with the winding up of the hose afterwards. And this was invented by an individual inventor, and he licensed this technology to a company called Emson, and they had a patent to this technology. So later on, Hoselock wanted to also make a very similar product, and they were ultimately sued by Emson and the original inventor for patent infringement. As part of its defense, Hoselock said that the inventor's wife had videoed the inventor using prototypes of this new product, both in the house and critically in his front garden, and that this constituted a public disclosure because the public could have seen this hose being used by the inventor. And Hoselock actually provided reconstructions of these videos in the courtroom to show where members of the public could have been standing in order to be able to see this hose being used. Now, it happens due to some clever argumentation that Hoselock were unsuccessful with persuading the court that this was a public disclosure, but it was a close-run thing, and certainly this is, it shows you how careful you need to be. If you're interested, you can still see these products actually being sold by Hoselock. So despite the fact they lost on that point, they actually won on another point. They found some other prior art that the court found that did in fact invalidate the patent. But yeah, it just shows you how important it is to keep your idea confidential. Okay, so now on to some success stories. The first one is an intellectual property right being used as a really good insurance policy for startups and small businesses. So this comes from a bit of personal experience of working in-house with a big company. A division of that company wanted to change a supplier for a sophisticated fixing that was in one of their products. They'd fallen out with the existing supplier, the personal relationship had gone sour, and so they approached another possible supplier. But that alternative supplier had noted that the first supplier had a patent to the original technology, and so they declined to supply the company I was working for. So the company I was working for, the division of that company, asked us in the IP department to have a look at this, decide if the patent was valid, and to see if they could in fact go to a different supplier. We looked at the patent and decided that we thought it was valid, and so we basically prevented them from going off and using a different supplier. They were told that they couldn't do that, or at least if they wanted to, they'd have to come up with a different technological solution which wasn't protected by the patent. And at that point, the desire to change the supplier suddenly disappeared because it was all too much hassle and too complicated. So it's just an example of a patent there being a really good insurance policy for a relatively small supplier with a really big customer who they can't really afford to lose. Something's gone wrong in the personal relationship, but that patent was a fantastic insurance policy for them there. It was respected both by the other supplier and ultimately by the company that I worked for. I have heard it said by lots of startups and private inventors that they're just concerned they're going to be bowled out of the water by a larger company in legal matters, legal fees, and so there's no point in getting patent protection or IP protection. But my experience is that, certainly personal experience working in larger companies, they will generally respect the valid IP rights of smaller enterprises. It's very, very bad publicity to infringe somebody else's patent. There's always a risk that that patent could be sold to a much bigger enterprise who might then see an opportunity to bring a court action. And frankly, it's just much easier generally to approach the smaller company and try and take a license from them or possibly acquire that company, which would be a much better outcome for that smaller company usually than just having their technology stolen. A second success story, or second successes, so helping to make companies investable. Registered IP is very often an essential building block for investment and growth. So as soon as you reach that point where you're looking for an investor, that investor is likely to do some due diligence and will then determine if you've got an IP strategy in place. And if you haven't, then they're unlikely to be very impressed, and they're going to be concerned about the idea simply being stolen. A patent is a very effective mechanism to turn an invention or idea into an investable asset. When it's just an idea or a piece of technology, it's quite ethereal and difficult to pin down. But once you've got a patent to it, the first thing that does is actually defines what the technology is in very clear legal terms. And the second thing is it says that you have a monopoly on using it for 20 years. So at that point, it's a much more investable asset than when it's simply just an idea or an invention. So a couple of examples of companies that have appreciated this. Square Inc. This was actually founded by Jack Dorsey, the founder of Twitter. He founded Twitter in 2007, I think, but Square was founded by him in February 2009. And this is a piece of technology which was inspired by his friend who was selling glass taps, but was unable as a small enterprise to take credit card payments because he couldn't justify having all the equipment. So between them, they developed a card reader that would go into the audio jack of a mobile phone, and that you could take card payments in this way. And this company filed patents consistently and in relatively large numbers from the early stage of the business. So that particular piece of technology that I just explained, the patent to that was also filed in 2009, the same year that the company was founded. And as a company, it received multiple angel investments and thereafter funding from investment capital firms as well. And the patents and the IP were key to giving confidence in that as an investment. Today, it's a $4.7 million business. It's not very well known in the UK, I think, because it only came here in 2017, but I think better known in the US. Another company, similar situation, GoPro. This was, again, just an individual inventor, Nick Woodman, 2003. He was a surfer, and he was frustrated that you couldn't get a film crew close enough to you while you were surfing to capture good images of you, and the fact that you couldn't film yourself either. So he basically came up with the idea of this harness that would strap the camera to yourself, which we all know as the GoPro today, much beloved by YouTubers. He filed a patent application to that harness, again in April 2003, so the same year the company was founded. I can't claim that those patents had too much to do with his initial revenue streams, which apparently came from selling seashell bracelets and camera straps from his camper, and from investments from his parents. But certainly thereafter he did receive obviously big investment, and again the IP was really been critical in that. You can see that the first patent, and this is a picture from that, again, was filed before the first camera system was ever sold in 2004. And revenues are now at $1 billion for that business approximately. Okay, and my final success, IP facilitating an additional source of income or an exit strategy for a business. So IP can bring in income by means of licensing of technology, and it can also be the basis of an exit strategy in terms of the sale of your business. And when you think about it, if you are a small innovative startup or SME, I suspect that 9 times out of 10 your chief asset is going to be your IP. It's going to be that fundamental idea that you have. It's unlikely to be your buildings or your stock, or perhaps even your people, because perhaps those can be tempted away. But your idea, your protected idea, is really perhaps the core of your business. So it's important to have that protected so you can basically realize the potential of your business in terms of a sale. A couple of examples of those. So SawStop is an American company, and it's based on an invention for table saws. So Steve Gass, he was understandably concerned about people chopping off bits of their bodies on table saws, and so he invented a system which passed a little electric current through the blade of the saw, and a different impedance would be detected depending on whether it was flesh or wood that was contacting the saw blade. So if it was flesh that was detected, then there was an explosive charge underneath inside the table, which shot a brake up into the table saw at very high speed, and the inertia of the saw brought it back down underneath the table before you'd had a chance to do any injury to yourself. So Steve, he initially tested this product on sausages before he realized that ultimately somebody was going to have to take the plunge and test it themselves, which he did. He apparently, it was very painful. Obviously this was a much earlier iteration of the product, but he kept all his fingers and it worked. He was initially unsuccessful in licensing this to existing table saw manufacturers. Apparently this was because they tended to want indemnities from him in case it didn't work, and they've been making claims that this was going to save your fingers or whatever. So he was unsuccessful in that, but so he then eventually manufactured the product himself. But in doing that, it became a successful product, and he managed to keep existing players out of the market with his registered IP rights. And licensing success did follow, and this is because the saw was initially designed to meet US regulations rather than European. But he was able to license the core technology to a company called Grigio, who developed the technology for Europe. And so he managed to get an extra income from the licensing revenue for that. And my final example is a company called Linkx Systems, and this is to do with selling your business and the role that IP can play in that. So this is again a small company. They recognise the waste involved in the packaging industry. So packaging companies don't want hundreds of different sizes of boxes lying around. It creates a big problem in terms of stock and in terms of procurement. So what they tend to do is just have a few different sizes of boxes and lots of them, and then there's a lot of wasted space inside the boxes. So this is very inefficient in terms of packaging and in terms of transport. So Linkx invented a system which measures, cuts and closes the boxes automatically based on their contents. They actually wanted to manufacture this themselves, and they spent 5 years trying to get market traction. But there were a lot of very big players in the market, and they did somewhat struggle with that. And they were approached several times by multinationals trying to buy the technology. So it's interesting that their IP is being respected, they're being approached rather than just having the idea stolen. And then eventually they did decide to sell to a company called Westrock, and the primary driver for that sale was the box sizer family of patents. That was really what the company wanted. It wasn't Linkx's premises or systems. It was really the patents that they wanted. They were a much bigger company, so that was the driver. Okay, and so that's all of my examples. Hopefully that was interesting. I don't know if we've got time for questions or if I've run over.
No, that's really good, John. Thank you very much. And we definitely have time for questions. So I've So anyone in the audience, if you've got any questions for John, please put them into the chat. I've got a few questions that I'll start with. So John, I think it's really interesting, the whole concept of when to do a patent and the fact that you need to keep your idea very confidential. Once you've my understanding with the patent process, it's actually quite a long process from the initial sort of registering your patent and getting the official date and time to actually going through the whole patent process. Once you've started that process, are you then allowed to use that invention as part of a product or a minimum viable product with customers, or do you have to wait until the patent is actually fully approved before you can do anything with the invention?
No, so the key thing about the confidentiality really is to get a patent application on file, and from that point on, any of your own disclosures can't invalidate your own patent application. So once you've got the patent application on file, you're free to disclose it from that point of view. Of course, whether or not you want to at that point is up to you. You might want to continue to keep it secret for a while. The patent system itself won't automatically disclose your idea for 18 months. So after 18 months, there's a publication of your patent application. So at that point, obviously, your idea is out there in the public domain, whether or not you've talked about it yourself. So yeah, you can get on with it from a confidentiality point of view as soon as you filed the patent application. And actually, you've got to, although it can take quite a long time for the patent application to grant, and for those of you that don't know, that could be anything from 2 to 5, 6, 7, even more years. That's not necessarily a disadvantage, because you have pretty good protection from the time of publication of your patent, which is the 18-month point, because damages can actually be backdated from the date of publication. As long as your patent eventually goes on to grant, anything that happens between publication and grant, you could obtain damages for that period.
Okay, that's really interesting. And I know some industries, maybe not deep tech industries, but other industries value things like trade secrets and corporate secrets rather than going down a sort of patent route. And I think obviously the reason for doing that is they just don't want anyone ever to know about that. And the obvious example is recipes for specific food products, where it's a corporate secret that maybe only a handful of people actually know the full sort of ingredients for a sort of a drink or a food product. Do you think that's a sensible approach for sort of more technical products, or would you advocate the patent route always?
Yeah, no, not always. I think you're right. I think it's very industry specific. So I don't know if you were thinking of the Coke example. I think their recipe, they've never really tried to protect that with IP. It's all just they've somehow managed to keep that very secret. I think it depends on how much of your innovation is going to be obvious from simply its use in the public domain. How much access are people going to have to it? If you think that somebody can essentially reverse engineer your invention from seeing it in use, and you want the insurance policy, then I think generally patents are probably the way to go. But yes, in very specific circumstances, you might be able to protect it with contracts or with trade secrets. There's always the concern, of course, that somebody else could independently invent your idea, and then you're not protected. A patent is much better from that point of view. It's a monopoly, regardless of if somebody else invents the idea later on. So it certainly provides an extra layer of protection, but there may be very specific circumstances where you are able to keep the idea very secret, and people will struggle to reverse engineer it, in which case it may be as well to use trade secrets rather than something like patents.
Yeah. The other interesting thing from my perspective is a lot of startups may have some ideas around an invention but haven't gone through the process of registering a patent, but they may be at the stage where they're talking to investors, for seed investment. And typically investors won't sign an NDA because they just talk to so many people and hear so many things that it's just not, typically they don't like to sign NDAs. So what would you say in that instance? Because obviously a startup's trying to showcase that they've got some novelty in what they're thinking and what they plan to do, but don't, obviously can only say so much. What's your advice in that situation?
Yeah, I mean, I think especially where somebody won't sign an NDA, filing a patent application is certainly would be the best practice way to go. I understand that, funding is tight. I mean, I don't know if people have a sense of how much a patent application costs in general. Perhaps it's worth just mentioning that. Normally, if you hire a patent attorney, which I strongly advise you to do, you're talking somewhere in the region of perhaps £3,500 to £5,000, depending on complexity, to draft and file a patent application. I don't know how that sits in terms of cost. I mean, obviously, for a very small company, that could seem like quite a big cost, but in the grand scheme of protecting perhaps your one really important innovation, perhaps not too great. Yeah, beyond that, I think it's being very careful about what you're actually disclosing. If you can't afford to do patenting at that point, and you can't get somebody to sign an NDA, I think you've just got to be very careful. And I think really then the investor, if they're refusing to sign an NDA, perhaps they ought to respect that. There are certain things that you can't say. It's not really in their interests to have this invention that they're potentially interested in disclosed and to become unpatentable.
Yeah, I mean, typically an investor isn't going to do anything with that information, but I think obviously startup founders are very cautious about that. We've had some questions from the audience. I'm just going to sort of start to go through those now. So one question from David is, what are the options for IP protection for software companies? We do things with machine deep learning, and I understand the patent route serves more for hardware companies. What's your take on that?
Yeah, it's certainly true that software patents in general are a little bit more difficult. It usually takes a little bit more skill and a little bit more effort to find something which is patentable within the invention. Patent attorney can often help you to do that. I won't go right into the details now, but there certainly are plenty of fintech, of AI, of neural network patents that are being drafted and filed at the moment. So it's certainly not impossible. What it really comes down to is trying to find something technical where there's a real world effect going on. So the things that are excluded from patent protection are programs for computers per se, and business methods. Those are the two sort of key problem areas, if you like. Mathematical methods as well, but those are probably the two main ones. So we're really looking for something which we can, the patent attorney will try and help you to find something which we can come slightly out of the software itself and talk about the effect that it's having in the real world. So for instance, there's a medical application, or you're having some impact on the hardware, or there's a broader system that you're affecting, like so you could say that an ABS system, the software for that is not protectable, but actually an ABS system is controlling the way that the car is braking, and so you just approach it from a slightly different angle, and you protect the innovation that way. So often it can be done, but sometimes not.
Yeah, and it's looking more at the application rather than the software itself. Exactly. I guess the software technically is copyrightable because it's a written piece of work, essentially, but that doesn't necessarily help that much.
Yeah, the thing with copyright is, of course, somebody could. You're right that the actual code itself will be automatically copyright protected, but of course somebody could use a slightly different programming style. And the other thing with copyright is you actually have to prove copying.
Yes.
Which is not the case with a patent. It doesn't matter whether or not somebody's copied you.
Yeah, no, that's great. Another question from Vicky, asking, how do you file a patent application, and do you need to do it through a lawyer, or can you do it yourself?
Of course, it's always, coming from me, it's always going to be a little bit suspect, but if you will trust me on any one thing tonight, I would say that it really is almost certain to be valueless if you try and do it yourself. It's just not one of those things that you can do yourself and get any kind of decent result out of. So what you're really looking for is a patent attorney, and they'll work with you to draft and file a patent application. There are lots of little cost-saving measures around in terms of delaying cost. Certainly, after that initial cost that I mentioned, you get a 12-month period really before anything else needs to happen at all. So there are sort of tricks to help reduce the cost if you talk to the patent attorney.
Yeah, and just to give my sort of hopefully slightly less biased opinion on this, having gone through this process myself, I think writing a patent is actually quite complicated, and it's not your standard document. So there's a lot to it, and actually engaging with a patent attorney is actually really valuable, because you'll avoid a lot of pitfalls and mistakes along the way, and sort of help you. And part of the trick, if I can call it a trick with a patent, is trying to make it as broad as possible, but also quite specific, so that you can sort of cover people sort of doing something very similar. I think I'm speaking correctly there, John. Maybe you'll correct me on that.
It's not at all difficult to file a patent application. You can do that yourself. It's basically writing a document that you file with the patent office. But whether or not it's actually going to do what you want it to do, it just won't if you do it yourself, I'm afraid.
Yeah, understood. And part of that is understanding what's already out there as well, to make sure that you're sort of avoiding any sort of conflicts, and that comes through the process as well, of course. But it's an interesting thing. Let me just look to see if we've got any other questions. So we've done that one. Wendy posted a question which was about how do you seek funding and support while also pursuing patent confidentially. I think we've touched on that a little bit, Wendy. So I think talking to VCs and sort of investors, most of them won't sign an NDA, and I think you have to give as much detail as you're happy and comfortable with, without sort of giving the crown jewels, as it were. So it's a fine balancing act. And then I think if you get to the point where you're sort of at term sheet and they're happy to sign an NDA as part of a sort of investment engagement, then you can sort of, as part of the due diligence, they'll obviously sort of get into the more detail about that. We've got another question. So Nadir sort of asks, if a patent has expired, is there any chance of renewing it?
No, once it's expired, which is 20 years basically, that's it dead. But you do have to be a little bit careful if you're thinking about being concerned about infringing somebody else's patent. There are things called supplementary protection certificates, particularly prevalent in pharmaceuticals, and patent term extension in the USA. So don't rely completely on me saying 20 years, but if you, I think if you sought some legal advice just to check that something was actually fully dead, then that's the end of its life. And no, you can't repatent something that's already been patented if it's exactly the same thing, because returning to my original point, really, the idea needs to be new and inventive, and so if it's already been out there in a patent, then it wouldn't be that, and so a patent shouldn't be granted to it.
Sure. And John, can you give us an idea of how the patent system works? So if I filed a patent in the UK but then wanted to file it wider in Europe and the US, what's the approach with that kind of thing?
Yeah, so you're absolutely right. So patents are a jurisdiction-based right, so you apply in the country where you want protection. So what we would typically do for a client that came to us, we would file in the UK first of all. That's cheap, and you get a decent quality search done as well. So what basically happens is that the Patent Office searches for existing prior art, existing knowledge out there to see if you can have a patent to the technology, to see if it's new and inventive. So by filing first in the UK, it's relatively cheap and you get a decent quality search. You then don't need to do anything else for 12 months from the filing of the UK application. And at the 12-month point, you can then file abroad, say for instance in Europe or the US, and do something called claiming priority, which is, so you claim priority back to your original UK patent application, and that means that for your new foreign patent applications, if you like, say your European and your US, it's treated as if you filed them on the same date as the UK. So by taking that approach, you delay the costs of filing in US and Europe, which is considerably more expensive, but you still benefit from the original filing date of your UK application.
Okay, that's really interesting. And have you got any other sort of advice that you can give to startups when they're looking at sort of this area in terms of their approach? Obviously, you gave some excellent examples of both the pitfalls and some of the success stories, but sort of overall, what would be your semi-biased opinion on sort of going through this process?
Yeah, I mean, I think I would say from an IP point of view, I would talk to a patent attorney early on in the process, very early on when you're still designing. Patent attorneys, they'll do half an hour free initial meeting. So, you know, if all they tell you is it's not the right time yet, then fine, you know, you'll know when is the right time. So it's just getting them involved early. We do get a lot of people coming to us too late. When they've already disclosed the idea, and so we're sort of scrabbling around trying to find small facets within the idea maybe that haven't been disclosed yet, and it's difficult then to protect the core idea. I think it's, you know, it's not spending money with a patent attorney necessarily, but it's just engaging them early to help you understand when would be the most effective time to protect, and if protection would be the most appropriate thing for you.
Okay, and we've just got another question. So what if you attempt to file a patent and go via a patent attorney, but it does not get accepted? Is there still a cost?
Yes. Unfortunately, yeah, the patent system is not set up terribly well for the individual inventor. But yes, I would say though that I think 60% of patents overall are granted, and within that, there'll be a percentage of people who try and do it themselves, and they will form a very high proportion of the ones that don't ultimately get something granted. So the percentage is probably higher than 60% if you're using professionals. Yeah, it's a risk. It is a risk. We can try and minimize those risks of it not granting by the quality of the draft that we do. So we provide lots of different fallback positions in there, so that even if we can't protect the main idea, perhaps we can protect a subsidiary idea, narrow it down during the prosecution. So it's really quite unusual. You know, I've dealt with hundreds, if not thousands, of patent applications. It's quite unusual for us to drop something completely. Usually we get something, but it does ultimately, that does come a decision point where you're having to say to your client, perhaps, okay, look, the patent office found very relevant prior art. We can still get protection, but it's for this very narrow area. Is that still commercially valuable to you to have that area protected? So that can happen. But yes, unfortunately, we've still spent our time and our efforts in preparing the patent application for you and prosecuting it. So there is still a cost, even if it fails.
Yeah, it's not a sort of no win, no fee situation. Unfortunately, it would be nice.
Fortunately or unfortunately, that's the patent profession. Yeah.
No, that's really good, and I think just a sort of a bit of perspective from my side. So I work with a number of different startups, and they have taken different positions in terms of having, you know, a nice sort of catalogue of patents, and to those that have got ideas on what they want to do from an innovative perspective, but have yet to start to develop that and patent that. And so while they've got the ideas, they're sort of waiting till they get some funding, which will then pay for the patents, etc., etc. So I think different startups will have a different approach to this, and partly driven by how core their idea and innovation is to their business. And I think ultimately it's going to be down to sort of personal sort of perspective and viewpoint. But I think, you know, when you get to the point when you're raising serious sort of VC money, they want to know how your product, how your idea is protectable, and of course patents play a big part of that. So I think it's very, very important. So John, I don't think we've got any more questions from the audience, but I think that's covered everything that we've got through. Let me just check. No, I think that's great. John, I wanted to thank you very much for your time and really appreciate that. I do now need to apologise to everyone because we're having a load of technical difficulties getting our other two speakers onto the Teams platform, so which is hugely frustrating and very, very annoying. And I think what I'm going to have to do is call this meeting to a close now and just apologise. What we will do is we'll get Tom and Ben back for another event. We'll probably use Zoom rather than Teams because I think we can probably get that working for external speakers a bit easier. But John, that's been a fantastic insight on the whole area of patents and sort of protecting ideas. So thank you very much for sharing your wisdom there with the group, and I'm sure many more will sort of benefit from this on the recording as well. So thank you very much for your time. Apologies. Yeah, thank you. And yeah, some great insights and some interesting stories on the sort of pitfalls and success stories, particularly like the one about Rolls-Royce. Actually, that was quite an interesting one. But yeah, so thank you very much. I really appreciate that. And thank you to everyone that's sort of joined us live and for the questions as well. A huge apologies to everyone. It's very disappointing. Unfortunately, this is the risk of doing our sort of first event. So we had some unsolvable technical issues, unfortunately, that our two other speakers haven't been able to sort of get in onto the Teams live. So I very much apologise. I will work with both Tom and Ben to organise either for them to record their talks and then we'll publish that, or for us to set up another event, and we'll probably I'll work with the tech team to figure out whether we can use Zoom or something else that's maybe a bit easier to get people joining. But thank you very much for everyone who's joined. If you do have any other questions or want to get involved with the Deep Tech Innovation Centre, please feel free to email me. It's andrew.pardoe@wbs.ac.uk. I'm easily findable on LinkedIn as well, so connect with me and talk with me. We are looking for lots of help in terms of mentors for the startups that we'll be incubating, for partnerships, corporate partnerships, as we start to do challenges and helping to support the startups with real life problems to solve. So we're really keen to work with as many corporates as we possibly can. So thank you all for joining, and we'll be running more of these events over the coming months. Our next event is the 2nd of December. So that's run in partnership with the Warwick Technology Professional Network, and so hopefully they'll have more luck with the technology than we have. So apologies for the hiccup there. We'll get this sorted for the next event, I promise you. So thank you all for joining, and hopefully if you haven't already got yourself a nice drink, please have one on me, as it were. So thank you all for joining, and we'll speak soon. Thank you. Bye bye for now. Take care.